Yes, welcome back, everyone, to the second panel this morning. First of all, I have to announce that we have to be quite strict with the time because at least two of the panelists have to get their bus to the airport, and so we have to finish at 1:45. But I'm so optimistic we got a very fruitful, insightful discussion as well. We are talking now about the victims and evidence, the recent developments. Recent developments, it sounds so simple, but the fact that we are talking about victims and evidence from the very beginning of the ICC is not so simple. And it took several years to develop the basic legal structure and jurisprudence. And I just mentioned the famous ICC appeals judgment in 2008 in the Lubanga case, where the basic lines of victims and evidence has been developed. And I'm so happy to have a wonderful panel here with me. And it's Nicole Sampson, and it's Paulina Macida, and Ellie Smith. And I will introduce everyone just before the presentation. So we would like to start with the prosecution, the burden of proof on their shoulders, and how they are dealing with victims and evidence. And Nicole comes from Canada, and she studied in Canada, Strasbourg, and Singapore. Prior to joining the ICC, she spent 6 years at the Toronto, Canada office of a private law firm, but now she is for over 13 years prosecution senior trial attorney at the ICC. And from 2005 to 2012, she was part of the team investigating and prosecuting Thomas Lubanga. And thereafter, she worked on appeals against conviction and sentence in Lubanga case. And since 2013, Nicole has been the senior trial lawyer prosecuting the case against Bosco Ntaganda. The trial ended in August 2018, and so we are happy that you join us, and the floor is yours. Thank you.
Get my watch ready so that we meet the time commitments. I'm a little bit outside in many ways of the main topics of the discussion today, which were extraordinarily interesting in the first panel, and I hope will be again in this panel, because I don't, strictly speaking, work for victim interests in the same way as some of the panelists have before. But victim interests remain nonetheless integral to the work that we as the Office of the Prosecutor do. And it is critical that we are able to understand, appreciate, and work with the interests of victims whom we meet regularly during the investigation phase, and then of course we use at trial as witnesses. And what I've chosen to speak about today is the specific issues, advances and issues and challenges that we have during trial proceedings with what I term dual status witnesses. Now, you may all know what a dual status witness is. It is simply a person who is both a testifying trial witness, either for the prosecution or for the defense, but at the same time has been granted the status of a participating victim, and therefore is equally represented by a legal representative at various stages of the proceedings. And since the Lubanga days at trial, where Paulina, Luc, and others were creating with the judges the law surrounding the rights and participatory scope of victims, I noted that we moved into Ntaganda in 2013, and very quickly we, through Paulina's office, because it was the OPCV who were representing victims in the Ntaganda case, but very quickly, we put together a series of protocols on various issues that were relevant for trial proceedings, but in particularly, and I think importantly, also in relation to dual status witnesses. So we were effectively codifying a series of decisions taken on issues that affect the rights and interests of dual status witnesses. And this includes, as a core component, the right of the legal representative to be notified of various issues that relate to the interests of their clients, and to be fully informed of things such as interviews that the prosecution wanted to have supplementary to an initial interview, or the right to disclosure, or the right to participate in medical assessments of their clients, the right in some cases to attend some of our witness proofing sessions, or other very important rights, including for security of witnesses. They're involved and are integral in those moments. And I think what happened, certainly in Lubanga and maybe in other cases too, is judges, certainly at times even the prosecution, definitely the defense, tend to overlook some of the witnesses who are victims in the case in terms of how closely we work with the victims' representatives. So having that codified was very important. As a result, you would think that the determination of who is dual status is a very simple thing. If they're on your witness list and they're equally participating as a victim, they're dual status. But actually, the identification of who is a dual status witness can be much more complicated than that. And that stems from the procedures in place at the very early stages of initiating victim participation applications. So, in fact, we, as the prosecuting office, didn't always know whether or not someone we had selected as a trial witness was also a participating victim. And the reason is the applications are anonymized. So during the trial proceedings, we would at times receive applications from the victim participation and reparations section, upon which we had to give observations, but we didn't have the identity of the individuals. So it was not easy for us to know whether or not the persons we had selected as victim witnesses were equally represented in the trial proceedings. Not difficult to find out. We have great relationships with counsel for victims, so we would routinely provide them with our witness list, and they would let us know if somebody was on the list. Exceptionally, at times, we also went through to the registry unit, which it's VPRS, which is a victim participation reparations section, to say, do you have an application for such and such a person? And again, they would routinely facilitate that. So the identification of who's dual status, very important. Also important to structure another protocol that we had in place, which was a protocol on inadvertent contacts with witnesses of the opposing party. So once we had identified a dual status witness, we had the obligation to tell the defense, this is also a dual status person, so that if you accidentally are in contact with a prosecution trial witness, you notify the prosecution immediately, but you have an equal duty to notify the legal representative immediately as well. And these are, I think, very good advances in the protection of victims' rights who participate in trial. During the trial itself, the legal representatives also had more enhanced rights to participate where it came to dual status witnesses. And for that, I refer to questioning of witnesses, for example. They're permitted to make applications, but where the applications concerned their own witnesses, they were generally always granted. The scope of the questioning had to be outlined very particularly for the judges to decide, and for the defense to determine whether they would oppose or not a particular application. But the interest of the victims who were represented to have further questioning done was always an important element that the judges took into account for dual status witnesses. And for the from the prosecution's perspective, this was an added bonus in many ways to the trial proceedings, because the legal representatives were able to tackle issues relatively limited to psychological harm, physical harm, damage suffered, reparations in some cases as well. But it helped portray the victimization that the witnesses themselves suffered. And it will eventually be useful if there is a conviction, for instance, in Ntaganda, as there was in Lubanga. It would be a helpful element to use when we're going forward and making requests at sentencing. That victim impact is important, but then equally in the reparations arena. But there are challenges that are particular to dual status witnesses that we as an institution have not yet resolved since the first trial, Lubanga. And one of them is the decision in Lubanga to withdraw the status of as participating victims of those dual status victims who testified at trial. Now, you may already know of that. I'll just briefly explain it. But when Lubanga was convicted, the prosecution had called 9 former child soldiers to testify as witnesses. And after a review of their evidence, the trial chamber was unable to rely on their testimony beyond reasonable doubt to prove either their age or in some instances whether or not they were in their armed group to inform a conviction because of inconsistencies in their accounts. And at times because of a lack of documentation to prove age. But in any event, a majority, so not the full chamber, but a majority also decided that for the 5 of those 9 former child soldiers who were dual status witnesses, they would withdraw their status as participating victims. So in effect, no longer eligible for reparations claims. One of the judges strongly dissented on that, saying that it was unfair to impose a higher standard of review on the evidence of those 5 dual status witnesses solely because they became prosecution witnesses and their evidence was scrutinized at a higher level. And that resonates with me personally because the standard of review for reparations eventually is balance of probabilities usually. It's not beyond reasonable doubt. And so what the dissenting judge was saying is there are so many, there were issues and contradictions between the witnesses' accounts, given statements given in 2005 versus testimony given in 2009 and 2010. But consider what the trauma experts have said in relation to how trauma impacts memory and the narration of memory and traumatic events, coupled with the low age of the children at the time of the events and the length of time that passed between the time of the events in 2002, 2003 and the ultimate trial, that it was unfair to them. And I think the most important criteria is the fact that they were being now evaluated at a beyond reasonable doubt stage. And what the minority judge was saying is they may very well have been under 15 and they may very well have been in the armed group. We can't say beyond reasonable doubt that they were, but perhaps on a balance of probabilities, the fact finder in an eventual reparations decision would find otherwise. And I think that's right. But we have yet to see in my current case, in Ntaganda, for which the trial just ended, whether or not we'll face the same issues. Hopefully not, but we'll have to see how that goes. And some other challenges that dual status witnesses face that are unique to their testimony are challenges that the defense can raise during the cross-examination phase of witnesses. So dual status witnesses, like any other witness, are open to challenges about their credibility, whether or not they're biased, motivated to lie, have poor recall, weren't at the particular place where they suggest they were, could be mistaken on facts, etc. And the witnesses that we call are usually strenuously challenged on various bases by defense counsel. Unique to dual status witnesses, however, is the fact that they have one further prior statement than any other trial witness. And that statement is the participation form itself. So in the very early days of the ICC, the VPRS, the dedicated unit for collecting, meeting with victims and collecting applications for eventual participation and reparations, they did so on their own, using individuals not always connected to the VPRS to help and assist them in filling out the forms and meeting with affected communities. And as a result, the forms themselves could be very lengthy and detailed in terms of what the harm allegedly suffered was. They faced challenges in that the language that the individual victim may be speaking is not the language in which the application forms are filled out. So you've got an interpretation issue. And what we've noticed even with our own prosecution statements, where we have qualified interpreters assisting us, there can be mistakes that creep in where a witness later will say, that's not what I said. And the prosecution has a practice too of full readback of a witness statement before that statement is signed. The VPRS and the persons that they used in order to collect the information didn't have the same level of training and, I would say, monitored ways of acting. And so the person who's taking the statement could be the interpreter, him or herself, so it's a direct interpretation, not qualified interpreters. And they don't necessarily do readback. And our experience through calling dual status witnesses is that they don't do readback. Because the defense would challenge an account that changes, either in very material ways or in lesser material ways, but the account varied over time. It's much the same as the situation that I think Luc was describing with the last reparations decisions, where the trust fund deemed that inaccuracies or inconsistencies between an application form and what you later told the reparations group were created, such that the believability or credibility of the witness was shot and they were no longer eligible for reparations. So you have this other line of vulnerability and defense and challenge in relation to the VPRS forms. And there have been some progresses over time to ensure that the forms contain more limited information directly related solely to the purpose for which it's created, which was, are you going to be entitled to participate as a victim or not in these proceedings? So much more confined in terms of the narrative, which is important, because as everybody knows, if you've taken a witness, the more times you meet them, the more times you get a different version of events. So it's important to cross-check, it's important to verify, it's important to meet the witnesses multiple times. But with every recording being open to further credibility challenges, you really have to be very careful and methodical in the way in which you collect any kind of information from a witness. And we, the prosecution's office, have very extensive disclosure obligations. So we were obliged to find statements from the VPRS, even where an individual was not participating. So for instance, what if someone who came to us and said that they had been a victim of a particular crime had also sought to participate as a victim, but wasn't granted status because their form made them illegible. So for instance, an easy example, which actually we had in the Ntaganda case, a person who didn't seek to participate as a victim in Ntaganda, but had sought to participate as a child soldier in Lubanga, whose first application was rejected because she said she was 15 at the time. So we felt we had an obligation to go back to the VPRS and try to ascertain whether any of our trial witnesses had been denied victim status, because that's disclosable to the defense, and it's open for them to challenge them rightly on that inconsistent account if we call them as trial witnesses. And in the example of the witness who had a prior witness application form in Lubanga, we did call her as a trial witness. We did disclose the earlier denial of her status. She subsequently had amended it in Lubanga and had become a participating victim because there had been an inaccuracy in the original application form. But we have yet to see how the chambers will deal with that particular contradiction in her account, because we put her forward as a child soldier based on what we believe to be credible information that she was under 15 at the relevant time. So it's a very important issue, because we faced it in Lubanga. We faced it again in the Ntaganda case, where witnesses were time and again questioned if they were dual status, and we had a lot more dual status in the Ntaganda case. Questioned about these inconsistencies, and some of the inconsistencies were outright lies, which one of our witnesses had accepted, because he fundamentally didn't understand, as many of them don't at that early stage, what it means to be a participating victim, what it means to apply to be a participating victim. And it all boils down again to the necessity at the very, very early stages of having a case opened, of having a very robust system of persons through this VPRS who can educate and inform potential victims who could potentially participate about what it means. So the Ntaganda witness who said he had lied on his form thought that he was going to get immediate reparation on the very day. So he had said that a person who had been killed was his wife. Turns out it wasn't his wife, but the wife of somebody else he knew. And he also stated that there had been some more property damage than there was, because he was misinformed. But he then, thereafter, once the prosecution met with him, he immediately confessed to this. And we called him as a trial witness nonetheless, and we elicited the fact of the untruthful information. He explained why he gave it, the misunderstanding that he was under, and we have yet to see how the chamber will rule in relation to that. But it's very important, because we assessed that that witness was, in the checks that we had done and the investigations we had done, was a legitimate victim of crimes that we had charged the accused with. And on balance, we determined it best to call him as to explain that victimization to the chamber. But we have to contend with these other issues, which fundamentally detract from the core work that we do. And so certainly getting much more robust measures in the early stages is going to be important, critical, I would say, in moving forward. And the last point that I will make, because I think we're really, my watch has not been all that good, is the practice at the ICC is quite varied in relation to the extent to which the prosecution has access to the witnesses it calls before those witnesses testify. We call that practice proofing, which is a common term used at the ICTY and other institutions. It's effectively where either party, prosecution or defense, can meet with a witness it's calling at some point prior to the testimony. It's very common in the Canadian system. I understand less common in the UK system, but it's not to coach witnesses. It's meant to explain the procedures to witnesses. You can evaluate certain, explain to them what does cross-examination really mean, because they don't always understand that, and they need the reassurance. They just need to understand what's the implication of giving something, lying at an early stage has implications later, or not having read back the victim application form can have implications later. So they must understand that and be prepared. And so not every trial chamber, however, grants the parties the ability to meet with witnesses beforehand. Luke will remember a famous example in the Lubanga case where our very first victim witness said, after several minutes of testimony, that he lied to the prosecution, lied to NGOs, lied, and it was quite shocking to us, and we were unable to speak to the witness because we had not been able to speak to witnesses in advance of testimony. Ordinarily, there are rules, of course, that preclude a calling party from speaking to a witness during examinations, but in any event. So Luc had a very important role for us there in speaking with his client and having him understand the process. Eventually, the client came back and gave the truthful account, we say, that he had given to us in the first place. And so the role of the legal representative is very important, particularly in cases where we don't have the opportunity to meet with witnesses beforehand and explain these particularities of a trial proceeding that, frankly, even most people in our home jurisdictions wouldn't want to face or be able to face. And it's especially the case when you deal with situation countries like the ones we were dealing with. Thank you.
Yes, thank you very much, dear Nicole. There is an ocean of jurisprudence in this field, and thank you so much for your presentation and linking this jurisprudence with your own practice. It was very insightful. Thank you. Now we are shifting to legal representation, victims and evidence, and Paulina Masida will give us her insight, and she introduced herself a little some time before. She is a member of the Genoa Bar in Italy since 1994, and she's working for the ICC since 2003. And since September 2005, Paulina is the principal counsel of the Independent Office of Public Counsel for Victims at the ICC. And currently, she's a common legal representative of victims in the Gbagbo case and the Blé Godet case and in the Ongwen case. She represents victims in the Lubanga, Katanga, and Bemba reparations proceedings and has represented victims in the Gaddafi, Kony, and Gbagbo cases. Paulina, the floor is yours. Thank you so much.
Thank you. I was hesitating if I wanted to stay sitting there or here, but since everybody was standing and considering my size, I thought it's much better to stand. Now, I will embark in an exercise which is always very difficult for a lawyer, to stick to 10 minutes. And in order to be able to do that, I have very clear bullet points of a presentation. Now, I think there is enormously to say, and there is always a debate on this issue of presentation of evidence by the legal representative and the possibility for legal representative to actually intervene in the presentation of evidence by the other parties. The presentation will focus on my side on the possibility for lawyers for victims to present evidence on behalf of their clients after the presentation of evidence of the Office of the Prosecutor in the trial proceedings. And I was thinking that it could be useful to focus essentially on 3 points. Why presentation of evidence by a counsel for victims, since the prosecution normally has the burden of proof and normally call quite a certain number of witnesses in a trial proceedings before the ICC. Second, which kind of evidence eventually a counsel for lawyer could present in courtroom. And third, some words about the challenges that a counsel for victims can encounter in this exercise. Now, first point I wanted to raise is why counsel for victims should call witnesses or present evidence, because we are not only talking of witnesses coming viva voce or connected via video link, but we are also discussing, for instance, the possibility of presenting documentary evidence or video evidence. Well, for one very simple reason, because it's true that the prosecution and victims normally share to some extent the same common goal, which is to see the person that they think is the perpetrator of a certain crimes to be convicted. But victims are in the proceedings before the ICC independent actors, and they may have, and normally they have, distinct interest from the one of the prosecution. Can give plenty of examples. I try to limit it maybe to 1 or 2. Think of a way in which the prosecution decide or not decide to charge certain crimes, or the temporal scope that the prosecution can choose. Well, these are issues which go to the core of the interest of victims to get justice for what they suffer from. Not necessarily the Office of a Prosecutor will cover exactly all the crimes that victims think have been committed on all the temporal scope or in all the location that the victims would like to be covered. But also in a trial, the office of a prosecutor may think necessary to focus more on certain type of crimes or certain specific issues which maybe are not 100% explored from the perspective of a victim. And I think, for instance, on the possibility of the office of a prosecutor to focus maybe less on gender-based crimes or on the extent of the victimization, which are, of course, core to the interest of the victims. Now, the practice of the court has been developing in at least two manners. First one, because it's now clear that victims can contribute in the trial also to issue going to the guilty or the innocence of the accused, which was not so evident. Jens mentioned the appeal judgment of 2008, because in the Lubanga case, when the trial chamber actually allowed the victim to eventually present evidence after the office of the prosecutor, that very decision was appealed by both the prosecution and the defense in the early days. So now we are very good friends, but in the very beginning, well, the road was a little bit complicated for us, and I see also Luke smiling. That very decision was appealed by both parties, which incidentally means something, but was actually confirmed by the appeal chamber. What is now in discussion, however, in the practice of the court, and I want to say this incidentally, is whether or not lawyers for victims can question prosecution or defense witnesses on issues going directly to the guilty or innocence of the accused. And you will be surprised to know that depending on the chamber on which you are, it can be yes or no. So if I'm in the Laurent Gbagbo and Blé Goudé case, but I can reasonably try to put some questions in relation to that. But if I'm in the Ongwen case, strangely enough, the presiding judge, who I think is a very reasonable person, by the way, don't get me wrong, but once we try to put a question to a witness in relation to the direct, some direct action by the accused in a specific event, then the defense stood up and said, well, wait a minute, well, lawyers for victims, they don't have a burden of proof, so why they should be allowed? But surprisingly enough, despite the fact that we explained that actually it's the core of the right to truth and justice, but surprisingly enough, the presiding judge made a comment, more or less verbatim, well, by the way, I will be inclined to support any objection going to that. Fine, apart from the fact that you don't support, in generally an objection, you just object and you can just say yes or no. It's not a generally. But by the way, apart from that, is outside the scope of my presentation, by the way. So this is just to show that there is an interest of the lawyers for victims to present evidence, because not necessarily all the elements that victims would like the court to present are covered by the presentation of the case of the office of a prosecutor. Or maybe there are aspects in the presentation of the case of the office of a prosecutor which victims would like to explore better for future purposes, for instance, for the reparations purposes. Now, the second aspect of the practice of the court is that the legal representative can present evidence, but with some caveat. This evidence shall not be repetitive of evidence already presented by the prosecution and shall contribute to the determination of the truth. Moreover, not automatically legal representative can present evidence. They need to request leave authorization from the chamber. So actually the chamber will evaluate these two aspects, if it's in the interest of justice, if it's useful for the determination of the truth, and if it's not repetitive, before allowing the presentation of evidence. I think it's probably easier if I give some examples of which kind of evidence can be presented by legal representative. any kind of evidence, this is something acquired, does not to be only witnesses or only documentary, any kind of evidence which is recognized by the court can also be presented by the legal representative. What I think is very important for a lawyer for victims is to know since the beginning which the strategy is. I mean, in a trial you need to know where you want to go, because otherwise it's a little bit complicated. Now, for a lawyer for victims, it's a little bit more complicated into brackets than for the prosecution and the defense, because the counsel for victims is there to represent the interest of their clients, and normally they represent a number of clients. So it's fundamental that a lawyer for victims is able to listen to the client, to have the time to meet with their clients, and to understand which are their interests. And I can give maybe two examples, one in the Laurent Gbagbo case and the other maybe in Ongwen, since we have spoken a lot about the Lubanga case. Now, in Laurent Gbagbo Blegude case, I think that everybody more or less knows, it relates to crimes allegedly committed during the post-electoral crisis in Ivory Coast between end of 2010, October 2010 and April 2011. Now, the first thing when I met with my clients in Ivory Coast that they said to me is, well, what is very clear is that I was targeted because I'm Jula. I am targeted because of my religion affiliation, because of my perceived or real political affiliation, because of my ethnicity. Now, I want that these things is known. It's not only because there was a discussion or who is the president rightly elected. We were targeted for a purpose. So the issue of persecution is fundamental, and they are really very keen about that. The second things that they said to me is, well, by the way, what happened in 2009 and 2011 is clearly the culmination of the deterioration of the climate which was prevailing in Ivory Coast in 2002. So for them, it was a continuum of action which culminated in events of 2010-2011. Why it's important for a lawyer? Because you can use that element, apart from the contextual element of crimes against humanity, you can use that element for persecution and for make the judges understand in the background. So it's something that for victims is important. It's something on which victims can contribute to the proceedings. So the decision in the Laurent Gbagbo Blegude strategically was to try to question witnesses on this issue of the persecution of people coming from the north or coming from neighboring countries, in order to try to have this element before the chamber. Now, the prosecution also did it, but sometimes the prosecution was not so willing, or their strategy was not important to push. An example, a witness came with a long list of names. Now, the prosecution asked the witness about the list of names. The majority of these names are of northern origin. Ouattara, Sako, but the prosecution did not pose the question. We posed the question, okay, and I read out the names. Ouattara, now, Mr. Witness, what these names have in common? And the witness said they are all from northern origin. Thank you. So these kind of issues, I think, are important for a lawyer to know in order to be able to represent the interest. And this shows that we have common interests but distinct. And I think it also shows that counsel for lawyers cannot simply equate it to second prosecutor, as normally, particularly the defense says. Coming back to which kind of evidence. It's always difficult to choose, because on some occasion it could be better for your client not to present evidence. In other cases, it could be important for your clients to present evidence. So there is always normally a discussion with the clients to understand if they want or not, and why not. In the Lubanga, in the Laurent Gbagbo and Blé Goudet case, we decided, for instance, not to present any more crime-based witnesses, mainly because of the attitude of the defense towards this kind of witnesses, particularly the defense of Mr. Gbagbo has constantly challenged the fact that the victims presented by the Office of a Prosecutor as witnesses with what status were not good victims. Or, to put it another way, they were fake. So why to expose again your clients? Because it's also a matter of understanding psychologically what does it mean for someone to stand in an environment which is completely different from their natural environment, in a country which is completely different from traditional background. So there is also this kind of issues that I think a lawyer for victims has to have in mind before deciding or not deciding. In the Ongwen case, what we decided to do was to present expert witnesses, because the Office of a Prosecutor actually decided not to have any expert in that case. So we presented one expert on gender crimes, one on child soldier issues, and the third one on the cultural background, which I think was quite important, because particularly lawyers for victims can contribute is also to help judges understand the cultural background underlying some patterns of conduct or some events. It happened in Lubanga when lawyers for victims were able to convince the chamber to call an expert on Congolese names. And it was here the case in Uganda because you are listening at witnesses who don't look at you in your eyes. Now, when someone just do like that, in my Western culture, it means something. It doesn't mean the same in the Uganda culture. But if you don't know as a judge, you may misinterpret what a witness is actually trying to tell you through his or her body. And it's very important. So this was also another aspect which was discussed by the legal representative. Last point, the challenges. Now, first of all, try not to be a prosecution, which can sometimes not be so evident because you tend to some extent, when you are a lawyer for victims, your reasoning is more or less the same as the Office of a Prosecutor. So it requires really a little bit of change in the way in which you think. So try to be complementary to the Office of a Prosecution. Second, the issue of limited resources. Normally, any lawyer, defense lawyer, victim lawyers, we don't have the same resources, as simple as such. We don't have analysts, we don't have psychologists, we don't have experts in ballistic, so you actually have to do everything on yourself, trusting your judgment, trying to see other ways of maybe having a pro bono consultancy with an expert which will help you to assess if a person is able or not to testify. So these are issues that render this exercise a little bit cumbersome. Issue of time, because very often when the judges decide to grant you the possibility to present evidence, they tell you that, you know what, you have an expert on gender-based crimes, 1 hour. It's nothing. Or an expert on cultural background, 1.5 hours. So you also need to be very clear on what you want from your witness, and you don't have the luxury of having witness on the stand for a lot of time. And last challenge that I would like to touch upon is more in relation to the relationship with someone who you will call to testify, because there is a work to be done before deciding if someone can stand or not before the judges, and there is also sort of work of to accompany, to some extent, the person in the exercise, particularly taking into account that the person will not be used to the courtroom if we are talking of a crime-based witnesses. If we are talking of an expert, they are normally very talkative. So you have different challenges also depending on the type of person that you will call to testify. And I think I will end with that, with this brainstorming session. Thank you very much.
Thank you very much, Paulina, for your presentation, and you gave a very good example how important it is to have the context and background of your client or witnesses to present here as witness. And here we are very happy to have Dr. Ellie Smith with us. Dr. Ellie Smith is trained in Cambridge, and she has a master from the London School of Economics and made a doctorate in Bournemouth University. She's a trained solicitor and now the principal associate of the company Global Security and Disaster Management. She makes a lot of research and is a member of several boards in this field, and her current research and publication focuses on the interactions of law with medicine and psychology. And therefore we are very happy to have you here with us to talk to us about victim testimony and credibility at the ICC, understanding the effects of trauma and memory. Thank you.
Thanks very much. First of all, Radina, very, very grateful for the invitation, so thank you. I just want to say just a quick sentence about the perspective that I hope I'm able to bring to the discussion. I began my professional life as a lawyer, but for the last 13 or 14 years, I've been working with the intersections between law and medicine and psychology. So most of what I do is I'm not a professional psychologist, but I work with a lot of clinical and psychological material, and I try to build bridges between medicine and psychology on one hand and law on the other, so that we can hopefully understand each other. So hopefully that's the basis upon which I proceed with this presentation today. So, what do we know? We know that international crimes can have devastating and long-term psychological consequences for individual victims, their families, their communities, and society more broadly. We also know that trauma is likely to affect to varying degrees many of the victims who appear before the International Criminal Court, either as a victim participant or as a witness. And we know, and Nicole's already mentioned it, that trauma symptoms can affect a victim's memory and as a result, their ability to provide an accurate, comprehensive, coherent and chronological account of what they either witnessed or experienced. Now, the court is obviously responsible for determining the veracity of witness testimony, and that includes victims whose memories have been impacted by trauma. So how then should it go about doing that? And that's kind of the area that I want to touch on very briefly today. So in the time we've got here, I'm going to kind of give a whistle-stop tour through just a number of psychological traumatic symptoms and just touch on the impacts that they can have on a victim's memory. And I should just say as well, it's the whistle-stop tour, it's not comprehensive. I've just picked out 3 particular symptoms for the purpose of this presentation, and it's also somewhat artificial because in practice victims suffer from more than one symptom. So I'll look at those symptoms, look briefly at what the court currently does, what its approach currently is to trauma-impacted testimony, and where perhaps it needs to develop further. Just before I get started, when I say trauma, this is what I mean. It's an adverse psychological response to an overwhelming experience of sudden or catastrophic events. I should also note that while I'm talking about psychological symptoms today, there's other clinical factors that can affect memory. So, for example, we might see forms of neuropsychiatric memory impairment where you have significant head injury. And even when you have victims who've lived through a kind of prevailing context of malnutrition, where crops have failed, where they're kept away from villages, or where there's vitamin deficiency, where there's starvation. All of those factors also can affect victims' memories. And also, I'm looking at the content of testimony today, but it's also worth noting that trauma can affect the manner in which testimony is given. And that's a separate subject, but it's just one to bear in mind, because that can also affect credibility assessment. And finally, it's really important to acknowledge that not all victims who appear to give evidence before the International Criminal Court will be suffering with ongoing trauma symptoms. But given the nature of crimes under consideration by the court, it's likely that a good number of them will have had a trauma response at the time. And even though they might now be relatively symptom-free, they are likely to still have some kind of trauma impact in terms of memory. Okay, so these are the symptoms I'm just going to very briefly look at. I mean, during chaotic attacks, for example, there's things like stress and anxiety and confusion when attack is, for example, a surprise attack occurring in the night, and all of that affects the way that memories are stored and processed. But these are sort of specific clinical symptoms. Avoidance can be, it's either voluntary or involuntary. Voluntary avoidance is just where essentially someone avoids triggers of an event. They avoid a location, they avoid talking to certain people who they might have, who may be witnessed, or, it's a voluntary thing. But there's also involuntary forms of avoidance where the individual's brain simply won't go there. And for as long as they're experiencing symptoms of avoidance, those aspects of their memory are simply going to be unavailable to them. Dissociation, similar, you have gaps in memory, forms of psychogenic amnesia. Dissociation is essentially the mind absents itself during the event, and the memories are there, but they're not readily accessible to the victim. But it's also worth noting with dissociation that victims can also dissociate when they're questioned about the event. So this has been observed. There's a researcher called Diane Bogner who's done some research with during UK Home Office asylum interviews, and catalogued victims dissociating during the interview as well. So it can happen at the time of the event, but also when they're questioned about it. And obviously, if you're a legal representative, that in itself can be quite problematic, because the situation is quite stressful. And finally, autobiographical memory impairment. This is knowledge within the psychological field is growing in this area. It's something that people have now been aware of for a few years, but it's not, the knowledge isn't vast. This is essentially our knowledge, our ability to give an account of a chronological account of a day. So it's with non-traumatic memories, it would be, I got up, I had breakfast, I brushed my teeth, I got dressed, and it's something that we can recount, and we can account it in a chronological way, and it's also something that we're aware of happened in the past. It's known as explicit memory, but during times of stress, high arousal, such as a traumatic attack, those normal memory processes simply fail. And there's sort of lots of different pathways that memories can travel, but explicit memory essentially fails. And we also have within our bodies something called implicit memory, and this is something that keeps your heart beating. It's when you tap your joints and your reflex, that's it. So that's all kind of implicit memory. It's the kind of stuff that your body does without you consciously thinking about it, and that implicit memory doesn't fail. So memories are stored, but they go through these implicit memory pathways, which means they're incredibly difficult to access. And what tends to happen, that people will retrieve memories depending on what questions are posed to them, and that can be a real trigger. There's a smell. People often have a really, really strong association with smell. So I had a client who collapsed outside a butcher's shop and felt cold concrete on her back, and it was that she had a psychological crisis and collapsed. And she'd been held in a cell and repeatedly raped, in a cell where other people have been tortured, and it was the smell of the meat. It was that raw smell, and it was that it was so evocative. But she knew that something had happened, but she couldn't piece together. So I mean, that can take a huge amount of time to piece those together. And from the perspective again of a legal counsel, if it obviously involves very, very careful questioning. But when these memories do emerge, they emerge in the present, so they can be deeply, deeply distressing because there isn't this an understanding that this is something that's happened in the past. They are relived at the time. So the first thing to note is there's no standard or expected psychological response in relation to a traumatic incident. Victims of the same or similar events can have very, very different psychological symptoms, and as a result, the quality of their memory can vary enormously. We don't fully understand why different symptoms arise in different victims. We know that the duration of a traumatic event can affect the severity of symptoms, and we know too that the traumatic response can be influenced by the personality of the victim, including, for example, have I got a slide on this? Their degree of sensitivity. So we exist on a continuum of hypersensitive to hyposensitive. So it depends where your client is along that line. So if someone is hypersensitive at one end of the spectrum, they will be very prone to traumatization, very, very sensitive. And at the other end of the spectrum, at the kind of like hypo, I mean, these are your friends who throw themselves out of aeroplanes to make them feel something. It's, you know, they're not easily traumatized. And you know, in practice, we all exist somewhere towards the middle, but that degree of sensitivity affects impacts. Also of relevance is whether or not the victim has a natural fight or flight response. And if I give you an example, for two women who were held in a room and raped, if one of them had a fight response, her focus would be on the source of the trauma itself and on the attacker. And for her, these are the core elements of the attack. For a victim with a flight response, her focus wouldn't be on the source of the trauma, it would be on, she could probably give you a really good description of the layout of the room in a particular location of doors, windows, because they're possible escape routes, and the presence of anybody else in the room, i.e. someone who might be able to help them. And also, finally, impacts are affected by the degree of resilience in the victim. So we all have our the natural healing processes, and to some extent we are able to heal ourselves. Not everybody, but to some extent. But that's also going to be affected by the degree of support that an individual has received. And if they're still living in a situation of insecurity, it's likely that the resilience hasn't kicked in yet. So that's a very brief whistle-stop tour. So how then does the court currently evaluate trauma-impacted testimony? Firstly, it's important to note that the court is alert to the possibility that trauma can affect a victim's memory. In its judgment in the Lubanga case, Trial Chamber 1 noted that witnesses who were children at the time of the events or who suffered trauma may have had particular difficulty in providing a coherent, complete and logical account. And very similar wording was used in the Katanga judgment 2 years later, and it also echoes what the courts have said, the ad hoc tribunals have said, because obviously this is the ICC doesn't arise in a vacuum. So it's clearly a positive thing that the court recognises that trauma can affect a person's memory, and it's also very positive that the court doesn't simply presume that because someone has suffered from trauma that they're not reliable. The approach, however, is a little problematic because it assumes some degree of trauma, some non-specific degree of trauma in the victims. And once that assumption has been made, that assumption is used to accommodate a certain degree of inconsistency, so long as those inconsistencies aren't material or deemed by the court to be material. And this approach isn't really consistent with what we know about memory patterns in trauma victims. We know, for example, that some victims will have very, very good memories. Some victims will have little or no memory of an event at all. So this kind of common degree of acceptable inconsistency just it can't really be substantiated. So by way of example, if you have a victim who suffers regular nightmares and flashbacks of an event, that individual is likely to have a better than normal memory of the event itself. So better than someone with avoidance or dissociation symptoms, but better also than normal, because they are reliving those events. And what we tend to see is with the passage of time, we tend to see variation in peripheral detail between interviews, but those core elements, we tend to see very, very different, there's very little variation, between in core elements. That story tends to stay the same. But by the same token, what is core depends on whether or not the victim had a fight or flight response. So it's not what the court thinks is core, it's what's core to the victim. So in fact, the proper evaluation of trauma-affected testimony requires an understanding of the quality of the individual victim's memory. And that involves an understanding of the symptoms that they have suffered and in some cases continue to suffer, and the degree to which they've been able to integrate their experiences. But most significantly, it involves an evaluation of the degree of consistency between the memory pattern demonstrated and in some cases in terms of and the symptoms that they exhibit. So, these are the symptoms, this is the memory pattern we see. Is there consistency between the two? And this absolutely isn't intended as a criticism of the court. I mean, these are still emerging issues within the psychological field. I'm not aware of any other court that's doing a better job on this issue. It's very much a developing and emerging area, but I feel very much that the court does need to keep pace. And it's going to involve, I think, much greater engagement with psychological expertise, probably a lot of judicial training, and potentially down the lines, possibly the development of some kind of framework so that we can objectively sort of assess victim credibility where there's trauma present. And recently, the thing to be aware of, it arises within a very receptive context. We have a court that's very conscious of victims' needs. So I'm relatively optimistic that the court can keep progressing this area. And one particular case has given me real cause for optimism, because in I can never say it, Taganda case, they called a forensic psychologist, Professor John Yule, to give evidence on how trauma affects memory. And it's the first time that the court's heard expert evidence on this particular issue. And they heard evidence for 2 days. So, in summary, the court's alert to the potential for trauma to affect memory, but the impacts of that have yet to be explored in its judgments. Evaluation involves appreciation of the quality of memory of the individual and consistency between symptoms and memory pattern, and the Taganda case offers an opportunity to explore the impacts of trauma, and I really hope the court takes that opportunity. Thank you.
Thank you very much, Ellie, for your presentation and for linking your general expertise with the recent developments in the court jurisprudence, which gives us some motivation and some direction where to follow up. Yes, here we are. I don't know if you have still time to join us for a final discussion. So now the floor is yours. Question, answered, statements. Yes, Ina. Do we have a mic? Oh, yes. Thank you.
Nicole, you highlighted very carefully the legal obligation that both prosecution and defense have with regards to disclosing exculpatory evidence, especially during proofing, to the extent that the trial chamber has allowed, let's say, the prosecution to prepare the witness for the testimony. One point that was raised by the prosecutors at the extraordinary chambers in the courts of Cambodia with regards to victim participation was that in preparing or improving preparing victims to appear before the court as victim participant, the legal representative for victims are actually collecting information which under that statute they were not obliged to disclose to the prosecution and defense. And I wanted to know in your practice at the ICC, what is first of all the legal requirement and what has the practice been so far with regards to the disclosure by the victims' legal representatives?
Can you hear me if I use this? Is that,
A little bit
I
higher.
tried, but that's good. Better? Yes. So just to come back to the first part of your question, hopefully I said it this way, only the prosecution has an obligation to disclose exculpatory evidence. The defense obviously doesn't have that obligation, so it's just our way. In regards to legal representatives, they don't have the same disclosure obligations. So they don't have any disclosure obligations unless they are granted the right to call evidence themselves. So if Paulina, in her cases, or in the Ntaganda case, it happened, and Lubanga, victims are granted the right to call evidence, witnesses in particular, then they're obliged to disclose statements. Thereafter, once we, the prosecution, gets access to the name of the witnesses, we look in our records to see if we have any additional information, whether it's exculpatory, incriminating, or incriminating is harder for us to use, but we tend to disclose at that stage under the Rule 77 obligations, because it may be material to the preparation of the defense. So the obligation sort of also extends to us. But Paulina, you can correct me if I'm wrong, but I don't, certainly in the cases I've worked on, the obligation to disclose, even when the legal representatives were calling victims, wasn't to disclose everything that they have about the individual. It was just statements and related documents that the legal representative intended to use during the course of the examination. So it wasn't information they may have from a conversation, because there's a certain privilege that attaches to that as well, that could undermine the credibility of the witness. Their obligations are not that extensive.
Other questions?
I'll shout.
Yes.
I'm intrigued, Ellie, and I guess Nicole, about the Ntaganda developments. I was always brought up to believe that evidence about a witness's credibility was inadmissible. In other words, you can't call somebody to say this witness is likely to be telling the truth because of these factors. There was no objection taken to that witness giving evidence.
I think in that case, Zini? I think in that case, it wasn't about a specific, an individual witness. It was broadly talking about the effects of memory. So it wasn't something to say you should believe this witness rather or not. But it was sort of 2 days of evidence where the individual kind of described all the different possible traumatic responses and how that might affect evidence that has been provided by witnesses in general.
Briefly, I'll just add that that's correct in relation to Dr. Yule, whom we called to deal with the general effects of and impacts of trauma on memory and the ways in which it affects how an individual witness can narrate an event. But we also did call in Ntaganda other experts, a medical expert and another psychological expert, to talk about the trauma of specific individual witnesses. And there was some litigation in relation to that on the second, for the second type of expert we brought. One was a a forensic pathologist, a medical doctor who had done a review of some of the injuries of our witnesses to determine whether, in her expert opinion, those injuries were consistent with the manner in which the witnesses claimed to have gotten them. So we had that expertise, one that we, the prosecution, called, and one that the chamber asked for in relation to a witness who claimed he had sustained a particular type of injury, and the defense challenged the injury and challenged the court to appoint an expert to prove that the injury existed. The chamber did that And the expert confirmed that the injury existed and that the injury was consistent with the manner in which the witness had indicated he had obtained it. And then in relation to the psychologist that we had also called for the 3 victims, we in Ntaganda had a particular issue in relation to sexual violence victims. So we called some sexual violence victims who had delayed their reporting of the rapes to the prosecution for reasons that we wanted the chamber to understand beyond what the witnesses themselves had explained about it. So it was probably in most part because of the questioning of investigators initially, didn't delve into topics of rape, but it was also because of the shame and stigma that they felt in reporting it. They hadn't discussed it with other people. So we felt it was important to have the judges understand that stigmatization is a common occurrence, and the delayed reporting of rape is common worldwide. And so this psychologist did that at a general level, but she had also met with the 3 women and spent time with them and then offered her opinion as to whether or not their account was consistent in her experience with the account of a rape victim. So we weren't, in some ways, it's bolstering the credibility of your witness. We were presenting the expertise as you, the judges, will form your own opinions on the credibility of the account and the inconsistencies and the delayed reporting. But here's an expert who will tell you that having spent multiple years in that discipline, underreporting is common for X reasons, and that certain symptoms and manifestations of these particular women was consistent with rape victims generally. And we litigated the issues, but in the end the chamber wanted to hear from the expert and did. I would note, though, that in Lubanga we also had a trauma expert. So in Lubanga, the prosecution hadn't called one initially, but the court decided to call one. So very much the same profile as Dr. Yule, only with a lot less experience than he had, but on the same topics. So you'll see in the judgment that some of this information comes from the expert testimony of a trauma expert.
Just something I want to complete about dual status witnesses, but in general, witnesses who are victims and vulnerable persons. You were focusing on the psychological aspects that are influencing testimony, but there are also social aspects. For instance, for a woman that has been raped, it's not only the problem she has with her own psychology, but she can also just have a problem to tell that she was raped in a hearing that will be seen or heard by family members, her own husband, her children, etc. You can have a problem of conflict of fidelity, conflict. Yeah, no, not confidentiality.
Conflict of interest?
If, for instance, for child soldiers, the person who is prosecuted was also the superior, so they were used to see him as some authority, and the feelings are it's a conflict of fidelity.
Loyalty.
Loyalty, voilà. So they criticize the accused, but at the same, they can also have the feeling that after all he was also protecting them, and also such social elements can influence, and I think it happened also. Yeah.
Can we take the last one?
Oh, sorry. Yes, please. Sorry.
Yeah, this is almost one for you, because at the national level in England now, all advocates appearing in the Crown Court at least have to undertake vulnerable witness training, and there's quite a rigorous program of training that we have to perform in order to be instructed or be capable of being instructed in cases which require examination of vulnerable witnesses. And I'm just interested in The Hague, what activity the ICCBA, the OPCV, and the OTP are encouraging and undertaking with respect to training of advocates at the ICC.
Yeah. No, I can only reply. I can only reply for lawyers within the office. It's for them mandatory to have course related, for instance, to questioning vulnerable witnesses or witnesses of sexual and gender-based violence. Because if you are representing this kind of people, you are exposed, and you need to know how to interact. And for a lawyer, it's very important the interaction and the relationship with people. But there are things that you can do or cannot do, particularly maybe when you meet with this kind of clients the first time. There are things that maybe you should say or not say, or how to interpret central signal that the person can convey to you, not orally but not listening to you, or appearing distracting, or using certain words. So there is a need to be educated in order to also understand, and to some extent also to prevent some problems. Because if you can understand what someone is trying to convey to you, maybe physically, then you could maybe avoid some kind of repeated trauma, re-traumatization. And also, by the way, it's also the other way around. Because if, as a lawyer, you are exposed to listen for 10 days of mission to a lot of people having been raped, tortured, it has also an impact not only on your psychological well-being, but also on your objectivity as a lawyer to represent the client. So I think a lot of trainings are needed in order to be able to cope with these different challenges.
I'll just speak for the OTP anyway. We do have a lot of trainings geared specifically towards investigators who are collecting the information from vulnerable witnesses, not to re-traumatize, and the ways in which to ask questions appropriately. They're also trained and certified in the PEACE model, which we generally have a lot of UK trainers who come over for that. As prosecutors, we also go through trainings as well in relation to especially sexual violence, but other types of vulnerable victims, and the ways in which to elicit information during examinations in court. And we like to know a bit about the interviews too, because we do sometimes participate in interviews. Within the Office of the Prosecutor, though, we also have a special unit dedicated towards it's the Gender and Children's Unit, but it's also dealing with vulnerable witnesses. So in advance of any interview of someone that for us may be vulnerable or traumatized or have a physical injury, etc., we engage an expert from that unit or from outside the unit that gets a consultant expert who does an assessment of the individual. It's not a deep assessment psychologically. It's just to understand if they're fit to be interviewed. So it's a very basic thing, but the person can remain nearby for any traumatic moments in the interview process and provide some form of consultation to the individual. Interestingly, though, I know a lot of our investigators have had the experience that when it comes to questioning vulnerable witnesses, not every breakdown means that you must immediately stop the interview and have an intervention, because they need to express the grief that they're feeling in the moment, but they generally also like to be empowered to continue. And it's a balancing exercise, and it's delicate, and you have to sometimes offer the break. But I've been in sexual violence interviews with experienced investigators where my natural inclination would be, the moment there's a tear, that perhaps we should stop. And the investigator said, no, I should empower the witness to continue if they feel comfortable. And so that's how we progressed, and the woman was very comfortable proceeding. But we do have the psychological support available in case they have a big breakdown.
Let me comment from our perspective. There is nothing from the council side You apply for the list of counsel, you have to prepare a formal file of qualification, etc. No one is asking for things like this, although everyone knows about the cases we are dealing with. If you are on the list of counsel, no one asks you at the ICC or ICTY if you make any training at all. You are not kicked out of the list if you are not participating in any training. This is something that has to be changed. We had, in 2017, in our General Assembly at the ICCBA meeting in The Hague, we had a colleague from England gave us an instruction how you are organizing training if you have vulnerable witnesses and clients, how you are doing this. And for sure, this is something we have to take over. Council and team members are entirely left alone with the consequences you described. And everyone who is doing work in The Hague for some years, we observed at the ICTY, ICC cases of burnout, of alcoholism, of breakdown. There's no structure for counsel. They cut legal aid 25%, but they do not offer any support like this. These are things we are trying to change and to establish standards, but it's about money, it's about people, about structures, it's about opinion and thinking that it is valuable for the court, for the institution to offer service like this. And it's absolutely necessary to do. Thank you. So, if there are not any further questions, I just want to say thank you very much again to everyone, to our wonderful guests and panelists, and for your time sharing with us, for your wonderful questions and statements. And I hope that you got new perspectives, new ideas. And if I have to sum it up for me in 2 sentences, I think it's quite remarkable, because the victims and evidence issue was one of the most controversial during the Rome Conference and at the very beginning. Could there be a fair trial for the accused if there are victims and evidence in the same courtroom? And we learned that there is a practice, a daily practice. There is jurisprudence, but in fact, there is a practice arrived on a daily basis. On the other point, the reparations issue, so much hope was put on this issue at the beginning, and where we are today. 90% of the statements this morning has been very critical with the situation where we are. It's about rules, it's about money, it's about something has to change, and this is what I take for me from this morning, that we have to do something. Thank you very much. Thank you. And some final words, perhaps from Ina. Ina, please.
Well, I would like to add one quick comment that I'm grateful for all the opportunity to work on this project with Professor Caroline Hoyle, with ICCBA, and I believe that this conversation and discussion today on the reparations and issues of victims and evidence have been thought-provoking and intellectually stimulating, and I remain hopeful that we will have an opportunity to cooperate in the future with new projects and to continue the work on the cause of victim participation at the ICC and more generally victim participation in international criminal justice. Thank you.
Thank you.
Thank you.